jurisdiction and stay were timely, and that the church autonomy doctrine is not an
We're back up and
affirmative
running.
defense.
Sorry, folks.
The United States Supreme Court and this court have held civil courts cannot adjudicate purely and strictly ecclesiastical matters. This is not one of those. As stated, and as the evidence before the trial court proved, not only are the issues not purely ecclesiastical, but they are not ecclesiastical at all. No doctrine is implicated, and none can be cited by the petitioners. We are only asking the court to determine, or we are not asking the court to determine who's in the pulpit, morals for membership, or anything approximating that. We are asking that a property dispute created by the petitioners, not by UMC, be resolved. With regard to resolving the dispute, it is true that the court must review paragraph 2553. We do not shy away from that reality because that reality does not strip civil courts from determining disputes about involving religious institutions. In fact, the case law overwhelmingly supports such a review, so long as the court does not delve into doctrinal issues. There are no doctrinal issues at play here because, thankfully, again, the General Conference resolved those very difficult issues by 2553. We don't question that resolve. We embrace it. Notwithstanding existing jurisprudence, petitioners claim that if a provision is in the discipline, which, by the way, they have stipulated is a covenant. They're trying to say it's not a contract and they're not bound, but they are by their own admissions. That automatically makes it an ecclesiastical issue that cannot be reviewed by the court. That is the crux of their argument. They say because we are asking the court to examine 2553 that was set in place by UMC's General Conference, that necessarily means the court lacks jurisdiction. It's just not the case. If that were the case, it would make meaningless all the deference approach cases that both sides have cited to this court. Some of the clearest examples of the civil court's power to examine governing documents, such as the discipline, and in addition to the United States Supreme Court cases cited, is the disaffiliation case of Gelder versus Loomis. It's a 1980 case, and the 1992 case of Fowler v. Bailey. In the Loomis case, interesting case, it was a disaffiliation case, and the plaintiffs asserted that the disaffiliation election procedure did not comply with the church's constitution for two reasons. The first reason was that the church doctrine was contrary to the doctrine held by the church's new affiliation, and the second was that the decision and ratification procedures were not conducted in compliance with the specific provisions of the church constitution. We agree with the finding of the court that the first issue was a doctrinal issue which the First Amendment forbids the civil court from determining, but this court specifically determined that it did have authority to consider and determine whether the church's action complied with the Constitution's elections procedures. In fact,
friends, as you come back on, sign on, let me know you're back with me and confirm that everything looks and sounds okay.
And based on their application of the church constitution, including applying civil constructs such as
is there a way for me to see a combined chat over there?
Parliamentary procedures to these provisions, and ruled with regard to that election. The request for reviews by both congregations before you is akin to the procedure examined in the Lumen Court and not devoid, and are devoid of any doctrinal issues. In Fowler, the court specifically stated, quote, church bylaws, articles, or constitutions specifying how membership is acquired, maintained, or lost have an obvious and important public value for civil courts in adjudicating church property disputes, end quote. That court also held that the court may determine the regularity of a church meeting, who is a member of the church, for determining who's entitled to church property. Further support for the review of church documents and procedures is found in the cases that we've cited on page 9 of the Church of Servant brief in this case. Also, there's guidance in the 1945 block case where the court made clear that civil courts will inquire into the regularity of church proceedings where property rights are involved. And in the 1973 Presbytery of the Cimarron case, where the court assumed jurisdiction and reviewed the national church's constitution and determined that the local church was bound by the terms and conditions of the Constitution.
So she's going through jurisprudence now.
And cite to any religious doctrine that Judge Timmons adjudicated in this case. She looked at the regularity of the process, which gave First Church and Church of Servant the right to disaffiliate with its property, and did not allow the petitioners the unfettered discretion to impair the rules or impose rules outside of 2553 that are inconsistent with that purpose. Petitioners should not be permitted to use the First Amendment as a sword to manipulate a disaffiliation process and violate these congregations' own First Amendment rights to determine with whom they'll associate. I want to address the issue with regard to the United Methodist judicial process. The church's decisions not to utilize what is an unavailable process has been criticized by petitioners.
Did one of the justices?
Thanks for letting me know. Yeah, I know, I do.
I didn't hear what she said.
That the church's decision not to use or utilize an unavailable judicial process has been criticized by the petitioners.
She shouldn't have called it the church.
And it does not create a lack of subject matter jurisdiction. In fact, neither party had access or has access to this process that the petitioners claim. Contrary to the strained argument by the petitioners, the UMC does not provide a system or process for either of these churches to seek the relief necessary to remedy the petitioners' breaches. There is no process for presentation of evidence supporting claims or even an ability to come before that judicial conference. Petitioners have proposed that pursuant to paragraph 2609 of the discipline, the ultimate legal authority within the UMC is the Judicial Council. We don't dispute that. However, the Council has ruled that 2553 is enforceable and that the parties, including the petitioners, cannot add terms inconsistent with 2553. That is the ruling today. That ruling stands. Petitioners claim that 2609 offers relief to these two churches is a canard, and it provides no opportunity for relief to First Church or Church of Servant, nor an ability for either to access such process. It doesn't even allow the petitioners to use that process. And evidence of that is the fact that the Texas Annual Conference, the Rio Texas Annual Conference, similar to one of the petitioners in this case, has filed a lawsuit in Bexar County to enforce 2553 against local churches. If this process were available to either the real parties in interest or the petitioners, it's really hard to believe that someone in the petitioner's shoes would go to a civil court in order to enforce 2553.
She was smart to bring up the Rio, Texas case.
I want to point out also in that regard that when it comes to enforcement of the trust clause, the petitioners have admitted they will go straight to court to enforce the trust clause. Also, in the disaffiliation agreements that are part of 2553, their local chancellor and the defendant board of trustees put a provision in that agreement that provides that any breach of that disaffiliation agreement will be determined by the civil courts.
Oh.
So they will run to the
know
civil
that.
courts when it pleases them, but
Yeah.
they're saying that we cannot and should not. It makes no sense.
Well,
The
it makes
case is
sense
about
if,
property. They're trying to nullify 2553 as regards First Church and Church of Servants.
hey, Bill Kilmer, good to
As
see
to
you, man.
the relief that was granted by Judge Timmons, the court in the Block case recognized that the propriety of civil courts exercising equity in church controversies for the protection of civil or property rights. That's exactly what was done in both of these cases. But for the petitioner's wrongful and purposeful actions, First Church would be disaffiliated today with all its property, and Church of the Servant would be considered with the other 47 or so churches that will be voted on next week. I want to do a little anticipation of what the petitioners will say, having heard some of their rebuttal before. They have claimed that their actions regarding First Church and Church of Servant are due to their care and concern for these churches.
Oh, yes, of course,
I
yes.
submit to you that actions speak louder than words. Where was the care and concern in 1995 when the bomb pretty much obliterated First Church?
Yeah, they covered this
The
in the First
petitioners
Church
allowed
case.
First Church's congregation to worship at the OCU chapel one Sunday, and after that, they were on their own.
Yep.
Thankfully, the Baptist Church took them in for 3 years, and they were able to worship there. And local businessman John Kennedy provided them office space at the First National Center. Both of these churches have faithfully paid apportionments. In fact, the Church of Servant is in the top 3 in the dollar amount of apportionments paid. They've graciously provided their facilities to petitioners for use of meetings, all that while both churches are funded by the selfless giving of their congregations. They argue that First Church cannot maintain its property. They've been maintaining this property since the land run with no help.
So she's just
from
relitigating some
petitioners.
stuff that's already,
I think it's
the stuff
notable
they've read.
that First Church, in the context of the disaffiliation process and per the judge's ruling, has deposited in escrow with the petitioners over $300,000 in disaffiliation documents. Again, they have assiduously attempted everything possible to comply with 2553, yet continue to be thwarted. They are ready, willing, and able to participate. What are we asking for? Could I have?
I'll let you go ahead and wrap
Okay.
up. Go ahead.
Thank you. We're asking that this court deny original jurisdiction, lift the stays, and return the cases to Judge Timmons to set new deadlines.
That'd be
so
awesome.
that these churches can exercise the rights given to them by the UMC
Yeah, give it back to Judge
disaffiliate
Timmons.
with
She
their
was all right.
properties free of trust before the sunset date. We submitted it's impossible for petitioners to have any harm, let alone irreparable harm, when the only relief that we're seeking is the relief that was given to us by the UMC and allowed to be exercised by so many other congregations. Thank you.
Thank you. Got a couple of questions. So you're suggesting to the court that the Book of Discipline is in fact a contract?
Yes.
Okay, and you made reference to stipulations. I presume that petitioners didn't stipulate that it's a contract, or his argument would be disingenuous. So what did they stipulate to precisely?
That it is a covenant.
Okay, all right. So the trial judge is fashioning remedies for breach of the Book of Discipline, and you're suggesting that that is a breach of contract remedy that she is fashioning?
I think that what the court did is look at 2553 and the process that is very clearly delineated in 2553. It goes step by step in the order that the process should take place, and the court looked at that process, did not change it, just simply said, here is what happens, here's what the evidence shows, And because of petitioner's breach, when you go to First Church, the breach being that they were not allowed to go to the April vote for disaffiliation.
Why not just say, yes,
that
breach of contract?
They would be allowed to go to a conference with that same makeup. Because but for the petitioners breaching their own obligations under the discipline, that's what would have happened.
Thank you. And now you suggested that your clients are not asking for any relief that is contrary to the Book of Discipline, but wouldn't compliance with the Book of Discipline be an ecclesiastical question?
No, not in this context,
Not in
Your
neutral
Honor,
principles.
because these are not, we're not talking about matters such as who's preaching, what morals, clearly, they, to use the word I used earlier, the UMC assiduously avoided the issue of human sexuality and took all the doctrinal ecclesiastical issues out of that matter and simply decided a property issue, and that is, we know you can disaffiliate. We can't keep you in the church, but we also have a history of a trust clause. And if you were to disaffiliate because of whatever issue, then you risk your valuable property. We don't want that to happen. We're giving you a property right. You can disaffiliate if you do these very clear things, black and white, and you take your property with you.
Mm-hmm.
All right, thank you very much. That's all the questions I had. Vice Chief?
Yes. Counsel, let's suppose that one of your church properties had a neighbor sue the church claiming that the neighbor adversely possessed part of the parking lot. And the neighbor goes down to district court and says, Your Honor, we've adversely possessed this property, and we're asking you to quiet the title to this portion in our name. Would you agree that state law would govern that lawsuit?
Yes?
And that would not be an ecclesiastical matter, would it?
No.
Just because the church is a party doesn't make it an ecclesiastical
I think he's
matter.
making a friendly argument.
As a real property lawyer, part of my time, I think it's a real property dispute.
And we're here today, and you're arguing this is a property dispute, but title is vested pursuant to the Book of Discipline's directive, is it not? Title to your congregation's property is vested pursuant to that which was ordered in the Book of Discipline.
Actually, interesting question. In both cases, the deeds, if you go to Oklahoma County, the deeds, the title is vested in the church entity with no trust clause within the deeds, within the public record. However, with reference to 2501.
Where's that audio? What happened? The video's still going. What's going on here? Okay, I'm gonna mess with the cable. I'll be right back.
State. You're at the lectern, and you don't have a state statute book with you. What do you have? You have the Book of Discipline.
There we go.
I have my state statute books, and I have.
Counsel, have you not raised the Book of Discipline in your presentation?
Yes, and
we embrace it. Excuse me, and here I look at counsel table, and what do I see? I see the Book of Discipline. So we have the Book of Discipline being argued by both sides.
Yeah.
You've told us that we must review this cause under Section 2553 of the Book of Discipline. And yet, you still tell us that this is not a church matter, it's a matter that the state should resolve.
It is not a purely and strictly ecclesiastical matter, and it does not implicate doctrinal matters.
I have no
It's a
further
property
questions.
matter.
Thank you.
I thought he was being friendly, but then he was being antagonistic at the
I
end.
do have a question, counsel. In your brief, you raised the fact that petitioners were untimely. I'd like
Yes.
you to elaborate on that, and what would be the effect if we found that was so?
Okay, so under, let me get my section right here, Your Honor. 1.191, I believe it's I, don't have it right in front of me. In order to obtain a stay, which stays were issued in both of these cases, or request original jurisdiction, the way that we read it is that has to be filed at least 10 days before the hearing or trial at issue. With regard to First Church, the petitioners knew on June 1st, and in fact they made an oral motion to dismiss based on subject matter jurisdiction. They knew that the court was exercising jurisdiction, and the trial or the hearing began July 7th in the First Church case.
She's
Their motion to
reconstructing a
dismiss,
timeline.
their second motion to dismiss was denied on that day. Therefore, their filing was way after the 10-day period with regard to First Church. Similar in the Church of Servant, they knew by at least August 1st that the court was exercising jurisdiction. The hearing or trial in that case was August 18th, I believe, Your Honor, and their filings were more than 10 days after that. Therefore, they were untimely.
And what would be the effect if we were to find they were untimely and dismiss this proceeding?
Then the stay would be lifted, and we would go back to Judge Timmons to get new dates.
Thank you. No further questions, Chief.
Justice Winchester. Justice Combs.
Well, to follow up, we also in the past have converted an application to assume original jurisdiction to an appeal, have we not?
I'm sorry.
To an appeal, to a direct appeal of the issuance of the temporary injunction.
That is,
We have done that in the past.
that is my understanding, although we still have the stay issue.
Right. A couple other questions, if I can, counsel. You argue 2553, and I think I understand your argument well, but to me, 2553 is a precondition to the transfer of the title. And it's a precondition that's established in the Book of Discipline. How do you get to where you want to go, which is a purely property case where the state of Oklahoma has jurisdiction, without complying with the preconditions established by the parties in the Book of Discipline?
Well, Your Honor, I believe you start with the fact that the absolute result of 2553 is the transfer of property without the trust clause being in place. That's the starting point. Okay. And how you get there are, as I said, very distinct processes to which we've complied. But
I think his question betrays that he didn't read
Let
the
me ask you
transcripts
this.
of the previous
Under
cases.
the petitioner's argument, your remedy to enforce 2553 would be within the church hierarchy, correct? Do you believe that remedy is ineffective and not available to you under the timelines imposed?
Yes.
Absolutely. Not only the timelines, Your Honor. Do you want me to?
No,
Okay.
that's, I just want to
Yeah,
make sure
it's
that I understood
impossible.
that.
Very good.
That's all, Chief.
Justice Darby. Justice Keene.
Morning.
Yeah, she did whiff
I'm really
on
loud,
that,
but
Duncan.
I'll use my
Thank you.
microphone too.
I like
all right,
this one.
so what I want to talk to you about is, the big argument first is, if there's a solely ecclesiastical matter, you agree we don't need to be here. But your argument is that that's not true because it is a property dispute.
Right.
What I've also heard you say, and what Justice Rowe was pointing out is, and actually what Justice Combs just mentioned, is to get to the property dispute, you have to go through the Book of Discipline, correct?
Well,
Which you would argue is a contract, and we can interpret it and all those things.
and both parties have to comply.
Right. and I asked this question of the counsel for the other party, if the question comes down to it is a mixture of church doctrine and property law, who wins?
We do.
Why?
Because the case law, both the United States Supreme Court
I love
and
that
this
she raised her
court's law,
hand.
is that it does not have to be a purely property issue, but it does have to be purely and strictly ecclesiastical in order to not have the jurisdiction.
How do you get, so are you arguing that
Hey,
the
Laura.
only way
Yeah,
something's
I
going
agree
to
with
be
you.
ecclesiastical is if the church is deciding who gets to serve communion or what kind of communion you're going to serve, or who's going to preach, like you said, on Sunday? Anything with a property dispute will always be in front of the civil court. Is that what you're saying?
It depends on how that property dispute comes about. Generally speaking, I agree with what you said, but
Okay.
yes.
But if the property dispute is coming about through a church-created process and church rules and church internal appeal processes, your argument is going to be, because at the end of the day it's about property, that becomes a civil matter.
Yes, and again, it does not have to be purely property, but I think in this case, it really is about the property.
Okay. Would you agree with me that this court's precedents and the Supreme Court's precedents so far, from what I can tell anyway, is, you just said defer to you. How do you read that in all the precedent where it says, above all else, the government needs to stay out of church business? I think Tabor says that. They established the ministerial exception because of that. They even talk about church autonomy, saying how important it is. And it's been around for a very long time. So if there's a intertwined issue, why would the deferment not be to stay out of the church's business?
Well,
That's a good
first of
question.
all, with regard to Tabor, absolutely, the state does not get to question the appointment by religious organizations of persons that have ministerial duties. I mean, pure and simple, and that is really, respectfully, all that the Tabor case does. So, beyond that, I'm sorry, can you go back to your question?
Just saying, why are we deferring to you if there's a mixture?
Right.
And I think that everything I've read so far is defer to the church.
No, because in this specific case, again, there obviously have been questions within the churches, within the denominations, about human sexuality. And in this specific circumstance, the UMC decided not to have those type of doctrinal disputes. And they fixed it. And they fixed it by a simple procedure that results
She's not
and is
answering the
intended
question,
to
I don't
result
think.
in the conveyance of property. And it's simply a procedure. We're embracing the procedure. We're following it.
I have a question about that procedure in a second, but at the end of the day, the remedy from the trial judge here was to order the church conference to meet, order a church body to meet, then order what part of that body had to appear. How is, in order to then vote on certain issues that did involve property at the end, respectively, how is that not a court butting in and ordering a church on how to do their business?
Because
it
the
not?
court is able to use
Oh, the bishop
equity
just got up and
in
left. I didn't
reviewing
notice that.
this kind of dispute. And but for
Maybe a bathroom break.
having a remedy, then the other side of this equation could take away rights with impunity.
Yep.
All that the court did was go by the process and make the process the way that it was delineated by the highest power of the UMC per the Judicial Council, there has to be a conference to vote on the disaffiliation. And that is what she did. Had she skipped a step, as frankly we suggested, that might have been an issue, but she didn't. She followed their process.
But the remedy here can be the problem, can it not? Because the remedy in the cases that the other counsel were talking about are church issues where it's two people fighting about property and the court comes in and says, under state law, you own the property. Not, this is how the process is going to accommodate how the church is going to decide who gets the property. Like you just said, the remedy for you would have been her just saying, you get the property, period, the end, we're done. Instead, we have the remedy for you is that you think is appropriate is for a trial judge to order church personnel to accommodate specific things that she's dictating in church process. How is that not ecclesiastical?
That is no different than all of the United States Supreme Court cases and the cases before this court where the courts have necessarily looked at church documents, whether they be their constitution, discipline, book of order, in order to determine various matters. They sometimes have to determine membership. That is a civil court in the context of the appropriate dispute, determining membership, determining voting procedure. The Loomis case is a great example of that.
Can you tell me on the record, and I didn't see anything, you're saying that these two churches have been singled out. I know there have been many other churches that have disaffiliated according to the process. For example, Asbury United Methodist Church in Tulsa that owns a huge campus in a very, very lucrative area of Tulsa. Did UMC give them their disaffiliation and property?
The petitioners, the equivalent of the petitioners, fought with Asbury, and Asbury brought in national counsel and ended up prevailing.
Okay.
Not in court. They didn't make it all the way to court, but it was not
Through
a
the
simple process.
Right. They disaffiliated according to, and inside the church process.
They
with a fight.
They had their vote. They signed a disaffiliation agreement just like we want to, and just like we want to, they went to annual conference and were allowed to disaffiliate. And, you know, again, it
But
can't...
Counselor, sorry, I'm going to interrupt.
Okay.
But my last question, I don't mean to talk too much. In both instances, I heard you say that you were barred from a vote, and I hear about equity and time lanes and why it's not fair. Is there also argument from the other side that was presented that, yes, if we come in and we find out that First Church isn't really a prospering church, and before you take the property and possibly just sell it yourselves and not have a church, whatever you do that or not, that could be an argument, that the church wanted you to go through certain processes, and the argument is if you had gone through those processes, you could have ended up going to the vote. Of course, you're going to say that that still was an impossibility, correct?
Absolutely would have been
Okay.
an impossibility.
And the other Church of the Servant case, they had a vote and it failed. And you're asking us to question, or the trial court to say, well,
there's
even if
Bishop
the
Nunn.
Book of Discipline rules are under 2553 doesn't say, well, you get to take a vote over if you don't like it. Is that barring them because they took a vote and it failed, and the church at the end, the bishop or whoever decides he doesn't want them to have another vote? Might not be fair.
Well, actually, the disaffiliation agreement, which was put together by the petitioners, allows that subsequent vote. The issue is that in that disaffiliation agreement, they said that you had to wait a calendar year.
Right.
And so if you wait a calendar year, in the case of Church of Servant, they would have voted again on either September 11th or September 12th. Well, magically, outside of the disaffiliation agreement and outside of 2553, the petitioners unilaterally imposed a deadline for votes of September 6th, with the Church of Servant, again, being the only church that affects. It's just impossible to see how you can have over 100 churches that are allowed to follow the process when you've got 2 churches ready, willing, and able to
All right,
follow the
thank you.
process.
Thank you, Counselor. You answered my question. I'll waive, Chief.
She was too
Special
long-winded.
Justice Rowland.
With regard to the Church of the Servant and them not being allowed to have another vote for 1 calendar year, and with regard to what I understand was the brakes being put on allowing the other church to hold their vote, there was some requirement that a conversation on church viability be held, correct?
That is as to First Church.
First Church.
Yes, sir.
As I understand your argument, you find the actions of the church governing body here to be arbitrary, to be calculated, to just not be maybe fair, and you think that's because your clients hold very valuable property. Is that about the size of it so far?
I would bicker with you a little bit about governing authority. As I said, the ultimate authority is the UMC. The petitioners are not the UMC, but the petitioners have certainly attempted to take away valuable property rights from us.
All right, with that amendment to my question, is it true that the petitioners here can be what I might find to be arbitrary or unfair? Is it true that the church autonomy doctrine places that outside the boundaries of civil court, even if I might not think it was the best practice for them to have followed, or any member of this court might think that?
The 2
The
churches
courts,
can be
including
arbitrary.
this court, have found that just because you're a religious organization, it doesn't take you outside the bounds of decency and civility. Beyond that,
Yeah, there you go.
the petitioners themselves have admitted that these congregations are entitled to the rights given to them under the discipline. They've taken those rights away with regard to these 2 churches, and that's our complaint.
Is there such a thing as a purely ecclesiastical question that is non-justiciable?
Yes.
But which, even incidentally, impacts property rights? Or does the impact on a property right make it the business of civil courts and take it outside the realm of an ecclesiastical question?
That's kind
I
of what
hope
the
I
blonde
answered this
judge
question.
was
So-
talking about.
In this context, which really the issue came up because of human sexuality and the way that the UMC
What if she could come back to
decided
us?
to deal with that issue. In this case, if one of these congregations had come in and said, you are not enforcing the doctrine like we think you should with regard to human sexuality, therefore, we're leaving and we're taking our property. I think that would implicate the doctrinal issue. Fortunately, as we said, the UMC has taken that out of the equation. So we're not going to talk about that. We simply are going to let you go and let you take your property.
Thank you, counsel.
Well, Duncan, with respect to
And
the
Special
arbitrary thing,
Justice Swinton.
anytime there's litigation, both parties can be arbitrary. That's the point of litigation, is to get the court involved to
Solution
determine who
that
was
you would urge
more in the right
so that going
or
forward,
more in the wrong.
case law would be clear where the lines are when there is a property dispute and there may be some necessary interpretation of a doctrine or a document of the church, where that line should be.
So you're asking me to put my black on, right?
Why not?
I think simply put, when you have an instance such as been presented in this case, where the doctrine is clear, it's unambiguous. It says what it says, and it goes step by step.
She's talking about
And again,
2553.
it implicates church property, no doubt about it, that if there's not compliance with that on one side or another, a civil court can come in, they can look at church documents,
I don't know why
And
the
if
justices are
needed,
not
to
sympathetic
remedy
to
the
this
situation,
argument,
can apply equity.
but they're very reticent to wade into it if
That
any part of
answer?
it is connected
Let
to
me try a different way.
Okay,
doctrine.
Part of our problem in Doe was the questioning of whether or not there had been, it was unclear as to what the standard was. What my concern is, if you see that the Book of Discipline, by adopting 553, created a property right, and the court finds that it's proper to interpret that because they created this process,
So far, so good.
is there a way to fashion a remedy for your clients that doesn't require a district judge setting deadlines or trying to tell the church when they will meet and how they will meet?
What would that look like? No.
unfortunately, I don't think there is, and the reason for that is twofold. One, you've got the sunset deadline
Yeah.
within 2553 that's dictated
It's got to happen by the end of the
both
year.
the UMC and the Judicial Council that approved that particular paragraph. So you've got that, and then you have the petitioners implementing the process and the dates that
Sorry,
they've
Paul, the
established and
volume's as high
implementing
as I
that
can get it.
process. And you have to mold those together. But at the end of the day, in our view, in our opinion, as long as you meet the sunset date, we think, and you do that pursuant to 2553,
Yeah, Dale, I think
we
she's
think that works.
allowing that it can be a
That
mixture.
said, can't take my advocate hat on. These congregations are hurting, and every day that goes by causes harm. So, we prefer a immediate remedy if possible. But yeah, I don't think there's any way to remedy this without setting deadlines, because that's the way that you follow 2553.
Thank you. That's all I have. Chief, away.
Thank you very much.
Thank you.
Okay.
All right, and the petitioners have requested 5 minutes rebuttal, and we're happy to accommodate that.
All right. So now the conference's council gets to get up and rebut for 5 minutes what the council for the two churches has alleged.
Just a few points. We talked about, there was a discussion about the valuable property, and there's at least 4 churches that have disaffiliated with far more valuable property, Asbury being one, and that was described as a heated battle.
Dale, I think the
represented the
conference
in that
just has to say
negotiation,
that
and it
doctrine
wasn't a
is
heated battle. We
involved
went back and
because
forth
in
on
Oklahoma,
the terms of
if
the
doctrine
thing, but
gets
it was
involved, they back off. And so that's what the line of questioning was about from the blonde judge is if doctrine's involved, then we have to back off because we have to
that
be
better?
very averse to
Sorry. Let me just run
interfering
through
with
the
church
internal,
governance.
the provisions that relate to the internal appeal process that we think they could have pursued. Paragraph 51 of the Constitution, it's in the paragraph 51 of the Book of Discipline, says that a bishop presiding over an annual conference shall decide all questions of law coming before the bishop in the regular business of a session, provided that such questions be presented in writing and that the decisions be recorded in the journal of the conference. And then paragraph 56 of the Book of Discipline, again part of the Constitution, says that the Judicial Council has the power to hear and determine any appeal from a bishop's decision on a question of law made in the annual conference when said appeal has been made by 1/5 of that conference present and voting, and then has the power to pass on decisions of law made by bishops in annual conferences. So again, the process for them would have been to bring it up at the annual conference, to say that ask the bishop to make a ruling as to whether, for instance, they say the general conference didn't give the annual conference the right to warp or ignore, I may be misquoting that, 2553, and they can't add terms inconsistent with 2553. If they thought we were doing that, if they thought that terms were being added that were inconsistent with 2553, they could have asked for a ruling. They could have appealed it to the judicial conference. The judicial conference would have, the judicial council.
Yeah.
And the judicial council
She
would
should
have
have
made a
addressed this
decision
when
as to
she got
whether,
up. This was not a realistic scenario.
arbitrary or not permitted, whether they were inconsistent with 2553, and they would have had their remedy. They didn't pursue it. They just didn't try. They didn't attempt to present that issue in a manner that would get it to the judicial council. We talked about whether the
He's not
church
wrong.
autonomy
I mean, like,
doctrine is
they
an
did not
affirmative
try,
defense.
but the reasons for that matter.
And I think there's a
I mean, they
little bit
didn't
of
try
a
in that way to
danger
get it to
in
the judicial
labels.
council.
You know, if you call everything that the church asserts is ecclesiastical law, as well, that's church autonomy doctrine, you encompass the case of Doe, where you have a non-member versus a member. You encompass, other cases which are probably sound like an affirmative defense, but to try and apply that to a case that involves a dispute between members as to purely
The June
internal law
session of the annual
of the
conference
church,
would have potentially been
that's a different animal.
a more
whether you
realistic
call it
option. I think you're
ecclesiastical
right.
law or whatever. That's a different animal. And the idea that we obviously have a dispute as to
Oh, Travis,
what
yeah, you're right.
ecclesiastical
Even if
means,
the judicial council
but the idea
rules,
that
nothing
it's okay
compels
for the government
them to
or courts
do what the judicial
run a
council
church,
says, which is,
to
what
become
happened
involved
with
in
Bishop
telling a church
Alavito.
what to do, so long as it doesn't pertain to whatever you want to characterize as doctrinal, so long as it doesn't pertain to, how you baptize
Very good point,
somebody, or
Travis.
how you serve communion or whatever, then it's okay for the government to get in there and run that church. I think that's just wrong. Ecclesiastical law is much broader than just the basic church sacraments or the basic church doctrine. It has to be for the First Amendment to mean anything.
It has to be for the First Amendment to mean anything. So does that mean, where do you suss out that line?
Your Honors, this process was intended.
I feel like
to be
it's been 5
non-confrontational.
minutes.
It was
Has it been
intended to
5
be
minutes?
a gracious means of bringing about churches disaffiliating, and for the most part, it has been for 87 churches so far, for another 47 perhaps at the annual conference meeting later this month. It has been. These could have been resolved in that manner as well. They just decided prematurely, we think, to head to court on it, and we think that's inappropriate. Thank you.
All right, thank you. I don't have any further questions. Vice Chief? No. Justice Cotter?
How many churches are left?
There were, in round numbers, in the Oklahoma annual conference, there were 500 and something that were part of the conference prior to the start of this process. This process started in 2019, and churches started disaffiliating.
Really more than 500? I want to say it was lower than
going through
that. I want to say it
process
was like in the
2020,
450s.
I believe. Of the 500 and something, there's
Are
probably
those
about
Oklahoma churches? 500?
500 and,
That's okay.
it's just in. So 325 will be left.
Mr. Morris, yeah, you
Give or
can't see the
take.
beginning of the live stream because it crapped out and I had to restart it, so sorry
Justice
about that.
Winchester? Justice Combs?
A couple of questions. The annual conference, I assume, is conducted once a year, one time annually?
That would be the suggestion by the name, but yes, that's correct. Generally, most years, it's conducted once. There were 3 special sessions of the annual conference scheduled in 2022 and 2023 to deal with the disaffiliation
With this
process.
issue.
Yeah.
And had they chosen to follow a dual approach, file a lawsuit in civil court and also file the procedure within the Book of Discipline, could they have done that?
Yes?
Thank you. That's all, Chief. I wait.
Justice Darby? Justice Keene? Justice Rowland? Justice Swinton? All right.
I guess I don't see
will
why that
conclude
has
the
implications
argument of
in
the case, and I
civil
wanna
court.
commend counsel on a very well presented and collegial addressing of a very difficult question. So I will commend you both, and the court will be in recess. Thank you.
Why? I guess I expected that the counsel for the other two churches would get a 5-minute period to offer rebuttal. That's odd to me that they didn't get that chance. But I guess it's the terms that they agreed upon. I'm going to keep that up in case they're coming back. I don't think they're going to render a decision super quickly. All right, so well, I'll keep the video up a little bit more just in case. So the issues that had to be at play, and then there are strong feelings on this. And I'm not a legal expert, so what is with this child walking around the courtroom? Who is that? That's just so weird to me. Okay, so I'm going back up to Dale's comment. So the way Dale was hearing it was counsel for the two churches was trying to make the case that it was not at all a doctrinal matter, and therefore it could be litigated just on neutral principles, right? But the language in 2553 alludes to a church that is unhappy with the doctrinal, the actions or inactions of an annual conference with respect to a doctrinal issue. And so that's the way in which this all gets complicated, because if it were purely just a doctrinal thing and there were no language turning to addressing, I got to turn this off before it starts playing another video. All right, yeah, that live stream cut out. It's done. So we're done for today. But the fact that 2553 in any way even alludes to a doctrinal issue is what's making the Oklahoma justices skittish, because if anything, at least in the United States of America, there is a high priority placed in protecting the First Amendment, and any way that you can chip away at that in the courts, it's very difficult to establish a new boundary line beyond which you cannot pass. And so I'm actually sympathetic to the slippery slope argument, even though I know it's called a fallacy, because, okay, if we change this norm, then what still protects? Where if the thing that determines intervention by the state is any reference to a doctrinal dispute, if we make allowances, as the justices were saying, anytime, okay, so is the new rule, anytime real estate comes into play, then if decisions are made that local churches don't like, then they can come running saying, apply neutral principles here and just ignore the doctrinal piece. And they were very reluctant to consider that. And I think that's a worthy line of questioning. The problem becomes basic decency, the notion of basic decency and fairness. So when you have an organization that claims to be ecclesiastical, claims to be upholding a covenant, but then is behaving in ways against that and then smashing constituent members under it, is there no legal recourse? And so that's what they're figuring out right now, is if it really is abundantly clear to any third-party observer that the conference is behaving unfairly, nastily, implicating fraud to some degree, as Duncan said, then can the state really not get involved at all? Do you get the right to trample on people when you claim to be an ecclesiastical hierarchical organization? Or is there a means by which people that are trampled upon can appeal to a civic institution to wade into those mucky waters? The Oklahoma Supreme Court, at least according to the questioning I saw today, seems to be reluctant to entertain this solution. Whether or not they agree that these two churches have been trampled upon, they seem to be very aware that this has First Amendment implications. And that's at least a non-expert outsider's read on the scenario. Something else worth acknowledging is the timeline of implementing and sunsetting the 2553 measure definitely put a bottleneck on things. And the bottleneck was not actually December 31st, 2023. It's the date at which the annual conference stipulated was the last time that you could go through the process. So that date has already passed, by the way, in Oklahoma. There's a special called conference a week from tomorrow here to dismiss the final number of churches here in Oklahoma. It's too late for Church of the Servant or First Church to get in good standing to do that. So they're trapped unless the civic institution gets involved. But there's this hypothetical, what if they had chosen to faithfully participate at the special called annual conference? It couldn't have happened. Bishop Nunn would have called such a measure out of order. But what if they had done it at the regular June annual conference? Hypothetically, yes, they could have brought it up and petitioned to get the 10% needed to send it up to the Judicial Council for a declaratory decision with respect to both churches, either church. They could have hypothetically done that. Problem is, Judicial Council moves slowly, and there is no enforcement mechanism for Judicial Council. So the general approach we've seen of the church is to delay and demoralize local churches. So if they had gone through that process first, rather than going the legal route, then it would have had huge long-term implications for the health of those communities. And then the conference could have done a number of things in the meantime to continue making it hard to sustain themselves. Even if they did do that, there's no reason to believe that the institution of the United Methodist Church or the annual conference would provide for these two churches against the conference. And so essentially what they did was they saw the writing on the walls and they went this route. If I had been in charge, I would have had them do the Judicial Council route simultaneously. Although then in that case, the civic authority or the courts could say, well, we just need to let this play out with the church courts. You've already started the process. And then if it doesn't work out, then you can file suit again in 2 or 3 years whenever it becomes clear that you're trapped. That would have huge deleterious effects on these congregations. So if the approach has to keep these two churches intact, then they probably went about it the right way, at least if I'm thinking about it right. Okay, so I'm going to look at the comments now. Okay, so U16B commented before, and that was a helpful comment. And now they say, from a purely communication standpoint, local church council spoke very slow and plodding. Okay, yeah, the council for the conference, he did better on his second appearance up there. But even though he was more nervous, I think you're talking about counsel for the two local churches. Yeah, the local church counsel was very slow and plot. Yeah, she goes too slow for me. I would have had Karen Nicholas do it. I wish Karen Nicholas, the other counsel defending the churches, she's a fantastic presence up there. But we got what we got. John says, when will the decision come down? I don't think First could have pursued both avenues, civil and UMC court path to disaffiliation. I mean, maybe they could have. I've talked about that. I don't know when the decision. I think they go at their own pace. So it could be later today. It could be in a week. It could be in a month. That's my understanding. And then we're hoping for a quick decision so that these local churches are not left in a lurch. Duncan says the last question could be important, and I don't think the petition's attorney answered correctly. I do think parties are required to abide by judiciary rulings in the UMC. In their Board of Ordained Book of Discipline. A remedy that would not affect the conference's operation would be to grant the congregations their property. So in my interview with Lloyd Lunsford, one of the things he helped clarify to me was all local churches do actually own their property. The problem is when you have established a trustee of that property, then even though they're not the legal owner, they become the effective owner, where they can actually do anything against the wishes of the local church on behalf of whom they are a trustee. So it gets really weird and hairy. here. But yeah, the question is not, do the local churches own their property? The question is, do they have any right to terminate the trustee relationship with the annual conference, or are they still bound to it unless they go by this process that the annual conference gets to decide how and when and where they do it and if they're faithful to it? Gabe says, I'm not impressed with either counsel, but I suppose it's tough to stand before the justices. Yeah, that's kind of a rare thing. I don't know if either of them had appeared before Supreme Court justices before. And the whole dynamic is just weird. Apparently, at one point I missed it, but one of the people there sent me a text message saying that 2 of the justices were joking while counsel was presenting. 2 of them were not regulars, so it was just it was a weird, irregular time, and it's an area of law that's very tense, and not everybody, as a Supreme Court justice, wants to make waves and start drama and potentially interrupt longstanding American judiciary precedent. Duncan says the conference's trustees could quit claim any property rights to their buildings. Yeah, they absolutely could. When we're talking about just all the things that they could do, yeah, but are they going to? No, they're going to only do what benefits the institution. All right. Hey, good to see you, Ms. Bourne. Thanks to everybody for joining in. At the end of the day, let's see, earlier we got up to 70 viewers. Now we're down to 55. But that's the biggest live streams I've ever done. So hopefully I'll get the kinks worked out here. I actually don't think there was anything I could have done to keep it from interrupting earlier. I think the internet crapped out for 2 minutes, and that was enough to kill it. But I am to do this more. I am to do this with next year's General Conference in the United Methodist Church. I wanted to be able to do it with the Carcano trial, but they made me swear that I wouldn't, and I'm no liar. But anyway, if you've enjoyed this, if you want more of this, then I just want to encourage you to go over to locals.com and find Plain Spoken and become members of my community over there. That's where you can fund the work that we're doing and make a lot more things possible in the future. So appreciate you considering that, and always appreciate the engagement here. This has been fun, but I'm gonna go now. I'll see you later. Let's see, where's my cursor? All right.